Hello, everyone. My name is Chris Johnson, and I'm a business lawyer and business person. In fact, when I was 22 years old, I founded a company that sold and serviced scooters. And at 25, I sold that company and I used the proceeds from that sale to go to law school, to pay for law school. Now, I didn't know anything when I did that sale and I messed all kinds of stuff up. But in the end, it worked. I wasn't sued. Things are okay. Things aren't always that way. And as a lawyer, I've seen a lot of things go wrong when people don't know what they're doing. It's very common for people to come to me now and they're about 3 to 5 years out and they're like, can you tell me what I should do to get my business ready for sale? And so I think most of it is just demystifying the process. There's a lot of people out there that will charge a lot to provide consulting advice to get a business ready for sale, or some business brokers will earn part of their fee as part of getting a business ready for sale. I, for not much money, provide a lot of advice to my existing clients just on things that they can do. I can't do a lot of the work for them. Now, the legal stuff we can, but the books and things like that, I'm not going to do, but they're very important. And I've seen these things from cradle to grave so many times now that I give them a primer on the process and what they should be doing now. I'm going to provide that same primer for you so you know how to sell your business. The first part I want to talk about is getting your business ready for sale. And I've outlined 3 parts that are important in getting your business ready for sale. One is your financials. One is your intellectual property. 3 is the organizational structure. So the financial preparation, getting your books in order. A lot of smaller companies don't have their books in order. Hopefully by the time you're getting ready to sell your business, you have a bookkeeper that you consistently work with that keeps your books in order so you can have accurate financial projections. And that's really what this is all about. No messy books. I've seen it kill so many deals, but also you're most likely sell your business based on how profitable that business is. Well, if you're taking tons of deductions, expenses to yourself, it's going to cut down on your profit. So there are ways to start paying more in taxes, essentially. So your company, it actually is a true reflection of what your company is making from the buyer's perspective. So they don't come to you and they're like, your profit's this, and then you're having to back everything out in this complicated pro forma that may or may not work to convince them that the company is more profitable than it is being reflected. Intellectual property. So this is something that we can do. Things like patents, trademarks, and copyrights are assets of the company. Getting those things done, getting all the contracts in order, cleaning up the contracts, making sure the contracts are assignable, having an employee handbook, having policies and procedures, all that ties in with the importance of the intellectual property. But I pointed that one out because intellectual property can sometimes drastically increase the multiple. And in that case, I'm talking about more the patents or things like software and stuff like that, that can make the company extremely valuable. So it's good to think about those things in advance and get those things formalized well in advance of when you're ready to sell the company. Third thing I mentioned was the organizational structure. So what I mean here is forming mid-level management layer and having standard operating procedures in place. So the acquirer isn't buying a job. To make your business more valuable, you cannot sell someone a job. People can get jobs. They can go on Indeed, they can apply for a job. Why are they going to pay you all this money just so they can have a job? They want to buy a business. They want to buy something they can be the owner of, that runs and operates on its own, that they can pay minimal attention to. Think about it more like an investment, like buying a stock, something like that. When you get your business to that point, your business becomes very valuable. And so a lot of that is getting your standard operating procedures in order and forming management structure so this business can continue in your absence. So how do you actually value a business? I just mentioned that before. Well, that depends on the type of business you're in. So one of the things you should do 5 years out is figure out how, the back of the napkin, how do we value a business like mine? It's very common to have a multiple of EBITDA. That's essentially profit, but it's earnings before interest, taxes, and appreciation. And you'll take a multiple of it. It could be a 3 times multiple, could be a 5 times multiple, could be maybe a 10 times multiple. That's more rare. When you start getting in tech companies, though, the multiples start increasing. I've seen in insurance companies lately, the multiples being pretty high. Throw in some software into there and you can supercharge your multiples. Now, other businesses, maybe more service-oriented businesses, typically trade a 1 times revenue, not profit. So you look at the whole year and then you just take 1 times revenue, and that's what they trade for. So these are things that you should know up front, just so you have a back of the napkin way of knowing what your business is worth. Once you get closer to actually listing your property for sale, you may want to pay for a valuation. They're not very much, and I have appraisers that I can recommend. If you have clean books and you have all the information they need, it's really not that big of a deal, and they can give you a more formal value of your company. So part of valuing the business is also looking at the eye of the beholder. You want to know who would want to buy me? What kind of company? Oftentimes it's a size of company. Like you'll see there's different stages where a company will get bought by venture, and then it'll go to the next level, and it will go to the next level, and then maybe it'll go public because there's really no one else that's large enough to buy them. And if someone is a good acquirer for that business, they're going to be more apt to pay you more. Let's say you start some social media company, your Instagram, for example. I'm not saying this is true, but it could have been something like they know we're going to start Instagram and we're going to disrupt and we're going to get a company like Facebook to buy us out. Sometimes that's the exit plan. So it's knowing who might be my potential buyers and how they're going to value the business and starting to really think about that now, because that frames everything that you're going to do getting that business for sale. Now, when you start actually putting yourself out there to the market, John Warlow, I stole this from him. I love his material. One of his books talks about the process of selling your business or marketing your business as like a striptease, like a stripper up on stage. And forgive me if that offends you, but that analogy it certainly resonated with me. So I'm going to use it. If it offends you, sorry. So the teaser, what kind of information should you have about your business so it attracts potential candidate buyers, right? I think about this as maybe something like a prospectus or an offering document that you would see for a commercial piece of property. So it would have pictures of the building. It would have demographics of the area. It would have other large companies that have a physical presence in the area close to your property. It's going to have the pro formas, the financials of the company, not in depth, but summaries listed. So a buyer could look at this business and say, this is something I want to know more about. So again, the stripper up on the stage, and it's revealing just enough where the people are like, yeah, I'm interested in that. Okay, so what do you do after a buyer looks at your teaser document and they're interested in finding out more? And you talk to them and they're like, well, I'm ready to take this relationship a little further. I want to find out more. Now you're ready for your non-disclosure agreement. Commonly, people will just refer to it as an NDA. So this is essentially a confidentiality agreement. It is definitely going to have confidentiality provisions, although there might be other provisions in an NDA. So it's really important to have this because the buyer is going to be asking you for information. Information that's confidential, information that if it was disclosed somewhere else, then it could hurt your business. And look, don't be naive. There are buyers out there that will put your business under contract with the intent to steal your customer list, to steal other information. And that's why when I'm working on producing due diligence to the other side, when I represent the seller, I tell them not to identify who their customers are. Sometimes the buyer fights that, but I insist. I'll anonymize the data. I'll have numbers like customer number 1, this is how much revenue they have. Customer number 2, this is how much revenue they have, something like that. But I don't give up the customer list. If the deal busts, that could be the most valuable thing. And Pandora's box has already been opened, with or without a confidentiality agreement. But if you don't have a confidentiality agreement, oh Lord, you have zero protection. So what I put in an NDA will depend on whether I represent the buyer or the seller. I'm representing the seller here. So all I'm going to want is a pretty simple confidentiality agreement, and I'm not going to want it to expire. The buyer's going to want to put some limit to the expiration of the protections of the confidentiality agreement. I don't even want to state anything. I just want to say, buyer, you can't ever use confidential information for any reason whatsoever. And there might be some other things I can put in that agreement too, but if I'm representing the seller, that's pretty much my focus. The buyer is going to want other things that, perhaps I'll include in another video that I'll entitle How to Buy a Business. So once you have the NDA signed, and the buyer might ask for additional information, you're not going to give them everything. Remember the stripper up on stage. You're going to maybe take off a little bit of clothing, just enough to entice them even further. You want them to enter into an LOI, also called a letter of intent. That's what it means. Some people will use a term sheet. A term sheet and a letter of intent is essentially the same thing. It's just the way that it's structured. Don't worry about it that much. Now, what you should know, the most important thing about a letter of intent is generally they are not binding. So you can agree on the price of the company. You can agree on different things. It's not binding. However, you can, if you think this buyer is really skittish, or if they're going to change the price on you later, you can make certain of the provisions in that LOI binding. Now, if it's not binding, why would you enter into an LOI to begin with? Because it really streamlines the process. This document is like the cliff notes of the deal. This is what the lawyers are going to rely on in preparing the definitive documents for the deal. And even though it's not generally legally binding, it is psychologically binding. So even if it's not legally binding, if the buyer just suddenly drops the price down significantly, the seller is going to feel slighted, and the seller is going to say, that's not what you agreed to in the LOI. I'm pulling out of this deal. So it is psychologically binding. So once you enter into the LOI, it's going to spell out what you're going to do next. The due diligence, the definitive documents. Sometimes the transaction documents will be signed, and then there will be a closing date later. And in the interim, due diligence is conducted. Sometimes the parties just go to conducting due diligence, and while they're conducting due diligence, they'll work on negotiating and finalizing the transaction documents, and they'll do what is called a sign and close. The date that they sign the transaction documents is exactly when they close. So there's generally two ways to structure a transaction. There is a stock sale and there's an asset sale. I've gone over to the differences in more depth in another video, but essentially with an asset sale, you're selling only the assets of the company and you are still retaining the shell of that entity. So why do buyers want to do that? Because they want to limit their liability. If there's any liability in that shell, they don't want it. They want to start fresh. They just want the assets. They want to take that. They put it into another entity. There's also some tax benefits to it, but sometimes there are reasons to do a stock sale. And that's what your attorney is there for, to help you figure out how you should be structuring this transaction. Once you figure that out, then you're going to do some kind of purchase and sale agreement. You're going to have different key sections, and I've done a video on this called The Anatomy of a Corporate Transaction, where I go into all the different pieces of a purchase and sale agreement. It's a pretty long document. It can be daunting. For the seller, they just need to understand the key pieces just so it's not as foreign to them when it comes time to the attorneys negotiating this document, and the seller is going to be involved in that process. They're going to be involved with their attorney. So the key sections are the representations and warranties, indemnification, the non-compete clauses or the restrictive covenants, and then the earn-out provisions. So the reps and warranties are the promises made by each side. So think about this like a type of insurance, contractual insurance, and it helps with due diligence, quite frankly. I can't tell you how many times through the process of the attorneys negotiating the reps and warranties, it's come out through the process that the company that's being sold isn't quite what the buyer thought. I see that quite a bit. And that's a natural part of the process. Indemnification is like an insurance too against third-party claims, indemnifying, covering damages and defense costs if any third-party claims happen as a result of certain things as spelled out in the agreement. Your restrictive covenants, which are very common when a seller is selling a business. Oftentimes the buyer will want the seller to stay on as an employee and help transition for a period of years. And then even after they've left, to have a non-compete for a period of years. And I've seen if there's no non-compete or for some reason the non-compete isn't able to be enforced, it can be disastrous for the company that's bought the business, because essentially the seller can just take the money and pocket it and then compete with the buyer, then it destroys the whole benefit of the bargain. So as a seller, expect the buyer to want some kind of non-compete. If they don't ask for it, good for you. As far as earnouts, I don't like earnouts at all. Sellers generally want to get paid everything up front at closing, and the buyers want to defer the payment of the purchase price. One of the ways that buyers defer the payment of the purchase price is by promising part of it as an earnout, a performance bonus, however you want to look at it. So let's say the buyer says, hey, I'll pay you $1 million down, and then, you can get a potential of $4 more million if you hit certain key metrics. So now they're hedging their bets and they're saying, seller, you have to do these things. You have to be successful in operating the company after the sale. The seller, when I'm representing the seller just wants the money, all the cash up front. And a seller financing isn't as good either, because they're not getting the cash up front. And there's a risk that the buyer defaults on the payment of the promissory note. I've seen it before. So when I'm representing sellers, I don't want seller financing. And if the buyer insists on seller financing, then I want personal guarantee from the buyer, and I want a security agreement secured by the assets of the company, as well as maybe the membership interests of the buyer, so I can make sure that the buyer actually pays on that seller's note. So the other aspect that may or may not be happening while we're negotiating this agreement, as I said before, it just comes in different processes, is the due diligence. Due diligence is a bear. As a seller, you are going to spend a ton of time getting all the documents ready to sell your business, all the things requested of you. The buyer's going to have an extensive list of things that they want from you that you're going to put into a data room, is what they like to call it. But essentially, it's just a Dropbox or some other thing where you're going to store data in a secured environment that's accessible to the buyer and the buyer's agents so they can analyze the deal. These are going to be a complete snapshot of your financials. It's going to be your contracts, other documents that they're going to request from you to evaluate the company to make sure that it is what you're saying that it really is. So one of the best ways to prepare for a smooth due diligence process is just get your documents together ahead of time. That's the number one thing, like I said before, get your books in order. Have all your tax returns filed, all that stuff. If you can quickly supply financial documents, that tends to be a lot of the process. pulling the other things together, the contracts, things like that. If everything's nice, neat, and organized, it makes the whole process much smoother. So now that we've done due diligence, now that we've signed the documents, now that we're ready for closing, final steps is just closing the deal. This is not as big of a deal as you would think. No longer do people go around a closing room physically signing documents. There used to be more of a closing ceremony. People will pretty much sign in advance. Once the documents are filed, they'll have the attorneys hold the documents in escrow. On the closing date, they'll be released from escrow in a nice closing package, and the funds will be wired or dispersed or however they're supposed to be according to the agreement. I like to have a call on the day of closing. I think that's really nice, especially it's nice for the seller to walk into a call and hear a buyer that's truly interested in the future of this company that the buyer is purchasing. So that's a nice touch that a buyer can do. Post-closing. There's going to be some post-closing things. They're typically going to be spelled out in the purchase and sale agreement. They're going to be on some kind of closing checklist for the attorneys to do. In particular, there's going to be the earnout. There's going to be that calculation at some point whether the seller has actually earned the earnout. There's going to be a working capital. I didn't even discuss that before. That's essentially just how much cash does the buyer need in the bank at closing, just so they can run the company in the ordinary course of business for a certain period of time without just throwing more money into the company. So are those working capital provisions being met? Or some things like that are going to have to be looked at after the fact, with most of the time with the assistance of your attorney. Disputes can arise looking at these things after the fact. So a lot of these provisions where there's post-closing obligations, it's really important to get it right and very clear and understandable, easy to follow in the actual purchase and sale agreement. So that's it. So how to sell your business. There's a lot involved to it, which is why there's professionals like me and my firm that do mergers and acquisitions, and there's accountants that do it and business brokers that make a living at doing this, because it's very hard, if not impossible, to do this task on your own as a seller. But look, hopefully I've demystified the process for you. My goal is for you to just generally understand what goes into it, so it's not as scary, so it kind of makes sense to you, so you can start preparing now, and so you feel better in the future when you're working on selling your business.